been protests, heated debates and a lot of political fireworks around the new Waqf law. But the new law is facing judicial review for the first time after being passed in both the houses of the parliament and post receiving the president's assent. In the latest, the Supreme Court has refused to grant an interim stay on the new Waqf Act, but has granted the centre 7 days' time to file its reply to the petitions challenging the constitutional validity of the new Waqf law. But what happens to the new law till then, and in what form will it continue to exist in the interim? There are 2 to 3 exceptions to the new act that will be followed at least for the next 1 week. To begin with, status quo will have to be maintained for the Waqf by user provision. To simply explain this term in layman's language, Waqf by user is when land used for Muslim religious or charitable intentions is considered as Waqf, even if it's not registered as such. However, the new law has abolished the concept of Waqf by user. So the first big takeaway from the Supreme Court hearing in the case is that the centre has conceded to Waqf by user provision, and hence both registered and unregistered but declared as Waqf properties will continue as is for the next 7 days. The next big takeaway is that for the next 7 days, no fresh appointments to the Waqf board will be made, which means appointing a non-Muslim to any Waqf board or council is out of question. Apart from this, even the character of any Waqf property remains unchanged. What's important to underline here is that the Supreme Court hasn't stayed any provision of the new Waqf Act. For now, it's the centre that has conceded to maintaining status quo as far as these 2-3 aspects are concerned. Any forward development can be expected only post the 5th of May. That's when the next hearing is to take place. But the question that then arises is, why has the centre sought more time before filing its reply? The answer lies in the tone and tenor of the Supreme Court bench headed by CJI Sanjeev Khanna while hearing the case on Wednesday. Basically, the Supreme Court was of the opinion that properties declared Waqf need not, for the time being, be treated as non-Waqf properties. So let's tell you about the 3 aspects of the new act that were flagged by the Supreme Court on Wednesday. Number 1, the Supreme Court was of the view that when a legislation is passed, courts generally do not interfere, but warned that if a property declared Waqf by user is denotified or treated as non-Waqf, it could have grave ramifications. Remember, as of today, several mosques and graveyards fall in this category. The Supreme Court spoke of basic logic and expressed how before the Britishers came, we did not have any registrations. Many of the masjids go back to 14th or 15th centuries, and so to require them to produce a registered deed is impossible. This is when the Supreme Court flagged the issue of the centre doing away with the concept of Waqf by user. Number 2, the Supreme Court raised concerns about the powers of the collector as mandated in the new law. To give you context here, the new law states in section 3C that if any question arises as to whether any Waqf property is a government property, an officer above the rank of district collector shall conduct an inquiry and determine whether the property belongs to the government. The new law further states that until the collector finalizes his or her report, the disputed property will lose its character as that of a Waqf. To this provision, the Supreme Court asked if this is fair. Basically, the Supreme Court sought a greater clarification on why have a provision where even before the inquiry by the collector commences, the property loses its Waqf status. And the third issue raised by the Supreme Court on Wednesday, the issue of non-Muslims in Waqf boards. This is where the Supreme Court questioned the Solicitor General Tushar Mehta and drew a parallel with the Hindu Endowment Act. The court asked if you will allow Muslims to be part of Hindu religious trusts. This issue came up as the new act mandates the inclusion of 1 member each from Bora and Angan Khani communities in state Waqf boards, and also additionally have 2 non-Muslim members. And now, viewers, given these observations by the Supreme Court, the Waqf debate is back in academic circles, with many critics of the new law citing the top court's view of the quote-unquote problematic provisions of this law in rejecting it entirely.